Good afternoon. I see we've got people joining as we make a start. We are talking about insurance notification this afternoon. Myself, Alice Cass and Anna Greenleaf from Devereux Chambers. Welcome to what is the second in our afternoon tea set of seminars. We hope you enjoy them, find them informative and at least a little bit entertaining as we on the brink of a bank holiday weekend. The way we're going to do the seminar today is we're going to do it by way of conversations, if we can, between myself, Alice and Anna, and we're going to look at insurance notifications in the context of some scenarios that we'll look at. Rather than just giving you lots of law on a Thursday afternoon when the sun's shining, we thought we'd try and pep it up a bit with a few scenarios to bring those ideas to life. Now, at the end, we might have some time for some questions and answers. So if something does occur to you during the course of the webinar, put it into the Q&A box. Don't use the chat. We're not using the chat box. I'm told we're using the Q&A box, which you'll see, should see at the bottom of your screen. So the things we're covering today are a refresher, an update on the law of notification, just to go through some of the cases to bring them to your attention. Hopefully you'll see those on the screen, on the slides. Then we're looking in particular at notification in the context of commercial insurance and looking at a scenario there. Then we'll be looking at notification in the context of consumer insurance. And both those scenarios will be ones that are driven by the present situation and notification issues that might particularly come out in this COVID-19 crisis. And then we'll look at block notifications, laundry list notifications, and have a look at, well, what's the limits, what's in and what's out. So we'll make a start and we'll start having a look at some of the refresher case law. The one that I always start with because I love this one. It's one that I litigated back in the day in Jacobs and Costa. It's lay here and low, because notification clauses can be in two broad sorts. And you should be giving notifications which either are claims circumstances which are likely to give rise to a claim, or circumstances which might give rise to a claim or may give rise to a claim. And so those are the two different scenarios. And in lay here and low, it was likely to give rise to a claim. And that was what was looked at as whether or not the circumstances which arise, which are known to the insured, are at least 50% likely to give rise to a claim. There's a 50% chance, more likely than not, on the balance of probabilities. And the circumstances in Jacobs and Costa were ones in which there was a personal accident and injury on the forecourt of a petrol station. And the petrol station owner saw the accident take place and saw the person being whisked off to a hospital. Went out onto the forecourt and couldn't see anything wrong, couldn't see any reason why the person would have fallen over. Now the insurance company, my client, said, well, you should have notified us at that point so that we could have investigated, we could have sent adjusters out to look at the forecourt, to take photographs and so forth. He only naturally notified much later when a claim was actually brought for personal injury against the petrol station business by the person who'd fallen over, alleging that there was some oil or slippery substance on the forecourt. And the Court of Appeal said, well, just because somebody fell over, just because there was an ambulance, we're not in such a litigious culture that meant that there was circumstances likely to give rise to a claim, because a claim could only take place where there was fault, where there was negligence, and there was nothing that the petrol station owner knew that suggested that there was likely to be a claim. The much more gentle wording, the wider wording, is the one that was in the Kidston's case that you probably know about. That's where circumstances may give rise to a claim. And that is weaker wording. It involves, as was suggested, some crystal ball gazing. What effectively was said in Kidston's, particularly at first instance by Elizabeth Gloucester, was that there could be uncertainty at the time when notifications are made as to what the precise problems are or what the potential problems will be. There might be, whether known or unknown, to the assured, a hornet's nest, which may get derived to numerous types of claims of unknown quantum and character, the date of notification. So whilst in principle there's no reason why such a state of affairs shouldn't be notified as a circumstance if the assured is aware of it, in each case the court says that the extent and the ambit of the notification and the claims that are covered by it will depend on the particular facts and the circumstances of the notification. So Kidson's helpful and unhelpful in the same breath. Saying that may give rise to a claim is a low test. We have that in the Folio case, the Collier case, which we'll come to in a bit, but also saying that it's all very fact dependent. And Europools, that's the newer case, which has looked at notifications most recently. It's quite useful for its summary of the law. It says that a notification need not be limited to particular events. It might extend to something that's general as a regulatory warning about a class of business or a concern about work done by a formal employee or entity. It can be a can of worms or hornet's nest notification, notification of a problem. The exact scale and consequences are not known, and it draws on Kidson's in some detail. And so it's a circumstance which might reasonably be expected to produce a claim. Alice.
Thanks, Andrew. So Andrew has looked at the cases on what the insured has to give notice of, and I'm going to look at the cases on when the insured has to give notice. The requirement for immediate notification isn't read literally. It's usually interpreted to mean that the insured should act with all reasonable speed in the circumstances at the first reasonable opportunity. The requirement for notice as soon as possible is placed into all the circumstances of the insured. The case there, Verelst, involved an accidental death abroad in January 1923. News of it reached the UK in February 1923, but it was not notified to insurers until the following January 1924, when the existence of the policy was discovered, and it was held that that was a valid notification. In practice, whether the requirement for notification is immediate, prompt, or forthwith, the courts are likely to construe it as reasonable notice in a reasonable time. Insurers may take points on the knowledge of or available to an insured when determining issues of notification. This is the last bullet point on this slide. The Kidson's case that Andrew was just talking about tells us that the concerns of the insured are not necessarily enough on their own for a valid notification without some external fact showing that there could be a claim. The case of Thorman had the example in it discussed in the judgment of an insured architect who realises after buildings have been constructed that she specified inadequate foundations, and she realises this when she reads an article in a professional journal. That's an example of an external fact which would be enough for valid notification to an insurer.
Excellent. So if we move on to a quick review of some of the case law about laundry list or block notifications. I mentioned a moment ago the older case, 1999, Rothschild Assurance and Collier. That's the case in which the Rothschild were the sellers of life assurance and pensions, and they had claims made, PII policies, and there was a review, voucher review, which was there to look at compensating investors to whom businesses like Rothschild had missold life assurance and pension policies. Now, Rothschild said no claims have actually been asserted. All that's happened is that we've done a review and that a number of investors have filled out questionnaire forms indicating that they think they might have been missold a policy. And there was a notification. And the policy wording in that case was matters, circumstances which may give rise to a claim. And this is where we get the beginnings of the authority, that there's a weak test. And there was a lot of potential claims, a lot of potential pension mis-selling policies. And there was a notification, a broad notification by Rothschilds. And what was said was that investors who'd taken part in the voucher review, who had accepted the compensation offered as a result of the review, had to be regarded as having made claims, and that the circumstances that Rothschild were talking about, well, it was only if a claim was potential, was possible. May was not likely. May was not probable. May was possible or potential. And that's where we got the language of a weak causal link between the notification and the eventual claims which actuate. McManus is the solicitor's negligence case. That was one in which new solicitors took over an old practice. I think they reviewed their files and they found 32 which had papers in them which showed that there was some negligence, there was some malpractice. And they thought, well, this may lead to a claim. And then they opened up the rest of the treasury and found 5,000 files done by the same solicitors in the same sort of way. And they notified those 5,000 in a block notification saying that these are files which may lead to claims of negligence and malpractice. It was held in that case that that was a good notification because, again, it was circumstances which may give rise to claims. There was no need to identify or notify the individual circumstances. And whether the notification was valid depended on what the nature of the future claim was and whether it arose from the notified circumstances. And what, in that case, there were some broad failings and negligence and malpractice identified at the outset. And the future claims, they arose from, they were causally linked to the broad notification that was made by the solicitors. And the last case on this slide is the Cultural Foundation case, which is architects' negligence, quite a complicated case in which you had architects and various arbitrations. And again, reiterating that this hornet's nest, this block notification is possible, but only to the extent that the circumstances identified are such that the reasonable person would think them likely to give rise to a claim. So here we have the likely wording rather than the may wording, and we have this analysis where you look at the reasonable person. You're not looking at the actual insured, where the actual insured subjectively thought that the circumstances were likely to give rise to a claim. You're looking at a objective, the insured on the Clapham omnibus. Would that person, the reasonable person, think that they would be likely to give rise to a claim? This claim that's subsequently made has to be sufficiently causally related to the fact, the happening, the event, the condition that comprise the notified circumstances. So it could fairly be said to have given rise to it. That's the causal link that's looked at. So that's a fairly swift rush through some of the case law. There's a couple of other cases that we'll mention as we go along that it's useful to have regard to. I might just mention now the case of Kojima UK Engineering and Underwriter Insurance, which is a 2008 case, which is another one in which the way in which notifications take place is summarised in quite an effective manner by Mr. Justice Aikenhead. I would go to Europol's certainly as the most up-to-date case, which has a really good structured approach to notifications. It sets out the test, and very helpfully it puts all of these cases we've been looking at into an order and into context. And so in some ways it's a one-stop place to go to when you've got a notification question, whether it relates to COVID-19 or elsewhere. But Kojima as well is one in which it was said that the insured must be aware of the circumstances that it's notifying to insurers. It's not enough to say, well, I think it's possible that there might be some unknown and unidentified design deficiencies in a particular building. That wouldn't be a good notification because the insured would not be aware of the circumstances. They'd be just guessing. And the Europol's case, the facts of that were that the insured designed swimming pools, and there were these rising and falling barriers, bars within the swimming pool to change the layout of the swimming pool. And they knew that the bars were defective, and they notified that in year one. They then notified specific information about the fact that the problem could not be overcome in a straightforward way and needed a complete redesign with hydraulics in the second year, the second policy year. The Court of Appeal, the judge had said it's only notified in the second policy year because it was only in the second policy year that the insured knew how serious it was. But the Court of Appeal said no. The insured knew that there was a defect, there was a problem with the swimming pools in year one. they notified that problem. It didn't matter that the insured didn't know quite the extent of it or quite what was needed to rectify it. And the problem was for the insured that in year one policy, the limit was already blown or was newly blown. And so they were trying to get it into the second year policy. So let's have a look at the first of the COVID-19 scenarios. But in order to put notifications into context, what we thought we'd do, and Anna's going to help us with this, is just look at the timeline. Remember, this looks as if it's we've been in the situation we're in for a very long time. But Anna, just tell us about the timeline. Take us through it.
Thanks, Andrew. So as we just discussed, obviously one of the critical issues when it comes to notifications is time. And as an insured, you don't want to be notifying too soon when you don't have the information that you need. But you also don't want to be notifying too long after learning of the circumstances which might give rise to a claim or however your policy is worded. So you're in effect looking for that sort of Goldilocks moment when it's just right. And on the screen, you'll see a list of some of the key events which could be relevant to notifications, particularly in the COVID-19 context. Some of the most relevant things I think we can see here are the FCO travel advisory notices. We've got two here, the first one on the 17th of March, and that was just an initial 30-day period. And then we've also then got later on the 6th of April, when they extended that indefinitely. We've also then, of course, got the so-called lockdown and the coming into force of the regulations, which meant that certain businesses had to close. So set against the context of those dates, we thought that the best and hopefully most entertaining way to explain the way notifications might operate in the context of COVID-19 is to look at two examples, one commercial and one consumer. And we're going to do that as a bit of a conversation between us. So here we are starting with the commercial example. Andrew and I are going to discuss the implications of a series of events as they relate to a commercial property insurance policy. So I'll just set the scene. What we have here is some warehouse premises. They've been left unoccupied now. They are locked up, but they're not being visited during the lockdown, and the warehouse manager has been furloughed. We have a property all risks policy in place, and that states, as you can see at the top of the screen, on learning of any circumstances likely to give rise to a claim, or on receiving verbal or written notice of any claim, you must tell the insurer as soon as reasonably possible. And then we set out a series of events, which you can see there. Day one, the alarm sounds. We know that this happens quite often. Day two, we get a call to say a window has been seen open. The director of the business is locked down there at this point. Day three, nothing seems to happen. Day four, the director visits when he's out doing his essential shopping, sees there's been a break-in, but nothing's missing. He doesn't think anyway. But day five, the warehouse manager is asked to visit and there is some missing stock. So even before the alarm rings on day one, we know the warehouse has been left unoccupied. And so, Andrew, do you think that even at that point, there's an obligation to notify the insurer of the unoccupied status, aside from the events that then follow?
So we have the wording which is more strict in this policy. It's circumstances likely to give rise to a claim and not circumstances which may give rise to a claim. Therefore, the insured only has to notify when there are circumstances which are probably going to lead to a claim. And on the circumstances, as you've outlined them, this is one where the alarm sounds, but it's a common occurrence. The alarm sounds doesn't mean it's likely, it seems to me, that there's a claim at that stage, because it might lead to a loss, it might not, but the insured would be guessing at that point. Would you agree with that, Anna?
Yes, I mean, I think what they may also have in their policy, but of course what we don't have here is any details of whether there's a separate notification clause for leaving your business unoccupied. And certainly it might be an area, if there is, in place where the insured is going to want to have a conversation with their insurer before they go ahead and do that,
yes,
before anything might happen.
Yeah, Marsh did a review of all the major insurers, and what they've done in regards to unoccupied premises. And most of the major insurers have either announced that COVID-19 does not need to, an occupation which is just due to COVID-19 crisis, does not need to be notified to them separately. A few of them have put in 60-day or 90-day unoccupied premises variations. But generally, there seems to be a market practice that it's not necessary, it hasn't been necessary for every business that goes out of its premises to notify insurers just because of COVID-19, on the basis that the insurers know that it's going to be common for premises to be unoccupied. We're not telling them something they don't already know.
And I suppose one of the other background issues that we have here is that the warehouse manager has been furloughed. Of course, that's increasingly common for many businesses now too, and it means that he can't legally work for the business. I mean, what effect do you think that has in this context?
Well, of course, we've got our reasonable precautions clause in the background, I suppose, and most businesses who have left premises are checking up on them. They're not allowing them to be completely unoccupied. Certainly our chambers, it's almost unoccupied almost all of the time, but we've got a member of staff, a non-furloughed member of staff, going in at least on a weekly basis to check up on it. And it does seem to me that you could be criticised for not taking reasonable precautions if you just leave those premises, depending on the nature of the premises and the nature of the risk, I suppose. But of course, yeah, you'll have a situation unusually for COVID-19, which you wouldn't normally come along, where you might not have the employee who's usually responsible for keeping an eye on the premises.
And actually what we've seen is that the Security Industry Authority has made it the case that workers who are monitoring alarms or security guards are deemed to be sort of critical workers. So it may be that in some cases they've also been kind of excluded from the furlough on that basis.
Yes.
So you've already expressed your view, I think, then on day one, we've got the alarm sounding, but we know it happens pretty obvious and pretty often. And we think probably then that we don't think that we need to notify.
Yeah, and then we've got the window seen open. Well, yeah, it's interesting that you see there, you might be getting a bit close, but again, the window open, I suppose if it was a premises which was highly secure, and a window open would really be an indication that there'd been a break-in. And so it could be that damage, property damage, maybe not theft is likely, but property damage is likely. So day two, even though the director's locked down and can't go and check up on it, it seems to me that at that stage, an insurer is going to have a bit more of an argument that things should be notified.
And then on day three, nothing seems to happen and we don't have any further incidents reported to us. But then on day four, the director's out and about and doing his shopping, and he goes to the warehouse. But he doesn't notice anything's missing. I mean, do you think at this point the situation is kind of now improved for the insurers?
Possibly has improved, doesn't it? Because it's looking at the reasonable person in the shoes of the insured, and the insured knows that there has been an alarm gone off, there is a window open, but having looked at the premises, if there's no damage and there's no stock missing, then there's no circumstances which makes a claim probable. So yes, things improve on day four.
But then takes a bit of a turn for the worse potentially on day five, because they then visit and find this missing stock. It seems to me that you're now aware of circumstances likely to give rise to a claim.
Yeah, I think I must be right, Anna, yes. As soon as you've got the missing stock, you know there's been a theft, you know that a claim is at that stage certain. So I suppose we might say day two that we'd have an argument, but day five it's pretty certain.
And how soon then, now we know, how soon do we need to notify the insurer? The same day, the next day? Well,
as soon as reasonably possible. Interestingly, the fact that this is day five means that possibly the court would be stricter on the insured than if it was day two. I mean, because as we know, as Alice has said, that immediately or as soon as reasonably possible just means within reasonable time. And so it might be on day two that because they're locked down, well, 24 hours, 48 hours might be allowable because it's reasonable in a lockdown circumstance. Whereas when you've already had 4 or 5 days, well, it may be that the insurer could say, by that time, you've had chance to think about it, really you should be notifying on that day, certainly the day after.
And it's interesting because the FCA has said that it expects insurers to consider very carefully the needs of their customers and to show flexibility in their treatment of them. But then, of course, it remains to be seen how how that then goes forward and isn't taken by the courts. And it's still
Have a
a
look at
fairly
the
vague statement.
have a look at the second, the travel, Alice and Anna.
Yeah, so moving on to this one then. Here, setting the scene, we've got an annual travel insurance policy, and that commenced on the 1st of September 2019. In January, we booked a holiday that's due to take place in July, 30th of July 2020, to Italy. And our policy wording requires notification as soon as you find out it's necessary to cancel the trip. So of course, when is it necessary to cancel the trip? And then how quickly are you going to need to notify your insurer? So firstly, what does necessary mean in this context? Necessary according to whom? Alice, what are your thoughts on that?
So my view is that necessary means not when it's convenient, not when the insured wants to cancel, but it's an objective test based on the reasonable person in the circumstances of the insured. So, for example, what we're going to come on to talk about in a bit more detail is foreign and Commonwealth advice. So the fact that the FCO would be advising against all but essential travel could be a strong indication that it is necessary to cancel the trip.
Yeah, and initially the Foreign Office advised against all but essential travel overseas for a period of 30 days. So I think in my view at this time, it wasn't necessary to cancel the policy or to notify, as the period of travel was outside that period. Do you agree?
Yeah, I would agree with that. At that point, it was around 4 months until the date of travel. So I'd say it wasn't necessary to cancel at that stage.
But then, of course, on the 6th of April, the Foreign Office advised against all but essential travel for an indefinite period. Was it now necessary to cancel the trip? On the one hand, you might argue that whilst that period of time being indefinite does now cover the 30th of July, it only covers that as of that date, and the Foreign Office reviews its advisory notices. So where do you think the line falls here, Alice?
So I agree. This is arguable either way, and I think it is on or near the line between necessary and not necessary to cancel. Thinking through both sides of the argument, the insurer may well say, well, it was necessary to cancel at this point because unless the circumstances change, we wouldn't be able to travel. But question mark, will they change? The insured may well say, well, I don't want to cancel now because the circumstances could change and I might be able to go. So practically thinking about it, at this point, is there really any harm for the insured in notifying insurers? Probably not. It would reduce the risk of the insurer saying that the insured should have given notification at that point.
And it's, they're starting to become slightly more ambiguous as well, because of course we're expecting an announcement of some sort on Sunday about relaxing restrictions. We don't know the extent of those, and we're starting to see some movement in other countries as well, including Italy. So do you think now maybe it's becoming slightly less necessary?
So we're putting aside what we've just discussed about what's the harm of notifying now. I think at this point, the reasonable insured could say, well, actually, it is reasonable to wait until Sunday, see what the Prime Minister says, see if there's any change to the FCO advice. I've heard on the radio, for example, that some countries, Greece was one example, are encouraging tourists and saying they still want tourists to go this summer. So I think that it would be reasonable to hang on until Sunday and see what the latest news is.
And we know that some airlines and hotels are offering people the ability to change their travel dates. Now, if you know that you have the option to change your travel dates, does that negate it being necessary to cancel, do you think?
So thinking about necessary, and also having had a look at some of the industry guidance, which I've seen online, I think the insured has to think about the various ways it could play out. So for example, can they have a refund? If they can get a refund, because they won't be able to move the trip or postpone the trip, so be it. If they can get a voucher, if that's acceptable to them and going to be something that they're willing to take the risk of having a voucher, again, that could be an acceptable way of avoiding making a claim on the policy. However, as I understand it, the insured isn't obliged to take a voucher instead of a refund, and so therefore would be entitled to say it's not necessary, it is necessary to cancel and therefore to claim on the policy.
And then I suppose if the Foreign Office says now it's fine to go, for example, and then but your hotel is willing to accept you, the flight is still showing as going ahead. It's a couple of weeks prior to the date of travel, say, but when you get to the destination, you know that the beaches are still closed and that isn't many restaurants. I mean, is it necessary to cancel then? Are you really going to be able to get the holiday that you booked?
So this is another one that I think is arguable. If you can actually go and stay in your accommodation, then I can't see on the one hand it is necessary to cancel. But as you say, if the bars, restaurants, facilities are closed, you can't go to the beach, you can't go to various tourist sites, then is the purpose of your trip really to sit in a hotel room? Question mark. So I think at that stage there would be a good grounds for saying it would be necessary to cancel the trip.
And one of the other contexts that we might need to consider, particularly at the moment, is there's a number of vulnerable people who've been told that they should be shielding. There's a number of people who are self-isolating. Does that make it necessary if you're in that category? Because of course we know that it is just advice to shield. It's not mandatory per se.
So I think in this circumstance it depends on the individual, their age, their vulnerability, their medical position. So taking the example of somebody who would be 70 or over, who would be classed as vulnerable in the current COVID circumstances, but is actually fit and well, what does the government advice say at the time they're getting ready to travel? What's their medical position? If they're fit and well, then arguably it's not necessary to cancel the trip, I'd say, just because of age.
Thanks. So moving on and turning back to Andrew then. Andrew, in your introduction, you mentioned that one of the other issues that insurers are facing is that of laundry list notifications. And how do you think that's going to play out in the current circumstances?
Well, we've got a situation where businesses may be tempted just to notify big and notify early because they know that we are in crisis situation and that things may go wrong and things may go wrong down the road. For instance, we've got here a suggestion. There's a travel agent who sold package holidays to clients, being package holiday protected, but here's on the grapevine that some package companies are not giving the refunds. Now, in circumstances where there's no actual complaints from clients, there's no actual client who has been not delivered the goods, the services they have ordered, where the travel agent thinks that there will be a problem in the future, but doesn't actually have any information about it. That's quite in the nature of a guess. And as we saw from the Kojima, and actually one of the questions that's come in through the Q&A is that we didn't have the Kojima name and the reference on the slides. So I'll just tell you, it's Kojima is Kajima, Kojima UK Engineering. It's a 2008 case in One All England Commercial 855. And that was a case in which accommodation pods were causing damage, and it was possible that they were causing some other damage, but that was yet to be investigated. And the case found that it was permissible and proper to notify the damage that the insured knew about, but that block notification did not go to things that the insured was just guessing at, things that might or might not be a problem in the future. The insured knew that the accommodation pods were not properly stably installed in the housing block in the construction, but the things that happened later were not really connected to the problems that were being seen at that stage in day one notification. So the travel agent can't guess at things in the same way a pension fund, somebody who's made investment decisions, started this crisis, starts reading complaints from investors. Well, there's something that the insured actually knows about, some actual knowledge. I think there's going to be some difference between a insured who just panics and thinks we're in a bit of a crisis, things could go wrong, people could complain, and the insured who starts getting in a trickle of complaints and then extrapolates, that's likely to lead to a torrent. In the first case, the insured is just speculating about what may happen in the future. In the second case, a bit like in the McManus case, the insured gets a small number of problems shown and extrapolates that because they've done the same thing across many more cases, there's likely to be many more claims actuating. And therefore, in the Manus case, the identification of 32 meant it was possible to notify the 5,000. Whereas in the Kojima case, the knowledge of the accommodation pods having problem X didn't mean that an unrelated, coincidental problem Y, which the insured didn't know about at the time, could be brought within the same notification. Now, plainly, the insureds are likely to notify widely, and the insurers are likely to try and reel it in, try to get more information and find out what it is about, try and find out whether there is that causal link between what the insured has notified and what happens later. And it's going to be important because almost certainly at the end of this policy year, particularly for the claims made basis, we'll see exclusions come in. There's a lot of debate at the moment about whether there's actual cover for COVID-19 as a notifiable disease. And in business interruption terms, Richard Howison and two other of our colleagues discussed that last week at the last afternoon tea. But if there is coverage and the notification is made, there's no doubt about it that you've got to get it into this policy year, because future policy years, almost certainly those notifications need to be valid now because the exclusions are coming in. We're coming towards the end of our time. We've got a couple of questions in. We'll probably only have time for one or two of them. I've mentioned the one about Kojima already. It's asked, there's another question about how much pressure insurers will come under to make allowances in relation to notifications, given the current circumstances. Do I think that insurers will enforce policies more strictly in the circumstances? Well, speaking first myself, I'll see whether Alice or Anna want to come in on this. We know that the insurance industry is potentially under huge coverage pressure. If there are really, really large numbers of large claims, then there isn't enough capacity in the market to deal with all the coverage. Therefore, insurers are looking very carefully at the moment at coverage points. And I suspect that at the end of this year and next year, they'll be looking very carefully at the notifications, because they will know that their exposure is great, and therefore they will not be slow to take points which will reduce their exposure to the market. As to pressures, well, we've seen already the Hiscox have come under a lot of pressure in the insurance press and in the popular press about going out early and taking a stand on coverage points in relation to COVID-19. So I suspect that we will have some public pressure, but I think that the insurers are going to stand up to that. I don't know if you've got anything to add, Alice?
So I would agree with that, although I think obviously it's going to be important for insurers to know which battles they want to fight. There's no point taking a firm view just for the sake of it and then ending up in costly and time-consuming litigation on lots of fronts at the same time.
Yeah. And we've been asked to circulate the slides. We can do that. Certainly, if you'd like a copy of the slides, maybe the easiest way is if you email events@devchambers.co.uk, and we'll make sure that you've got those. There's not a lot in them, but there's a few useful case references, and I'll add the Kojima one in before we send those out. And we're really over time now, and I can see a few people are signing off, but there's a quick question. If an insured makes an invalid block notification, would we recommend them asking for clarification and give them an opportunity to perfect, or should we wait out the clock? Well, often insurers will go for and ask for some more information, because they don't want to be taking the risk that actually later looked at, that hornet's nest will be good enough. And so by asking for more information about the notification, by getting more information, it makes it less likely in some ways that what is being notified is causally related to what might happen later. I think you've got to try and pin the insured down a bit more. If it's a very wide worded and very broad notification, then really pinning it down a bit is quite useful. So I would say that an insurer shouldn't wait out the clock, and it's not just that they'll come under criticism, but in some ways they're taking more of the risk. Any other thoughts on that?
I agree with that.
Okay, well, I think we've come to the end of our 40 minutes plus. Thank you very much for joining us as part of the Devereux Chambers afternoon tea series. Commercial topics particularly insurance topics related to COVID-19. Really very, very good to see so many people. Slides will be sent to all attendees in the feedback request email. I've just been reminded. So we'll let you know about the next in these series very soon. Thank you much for joining us.